Okay, so we are picking back up. We are now on slide 9 of topic number 2. And we're just back to a few last corporate tax building blocks before we get really heavy into the mechanics of corporate tax. So here on this slide, we're talking about control. There are two different types of control that are relevant for income tax purposes. So depending on what rule you're applying, there will be different types of control that you care about, and in fact, in some instances, potentially both types of control will be relevant. But you do need to identify which type of control you're dealing with, because that's really going to impact your analysis of how some rules are going to shake out or not shake out. So the first is what we call an Amazon delivery, but that's the first is what we call de jure control. Which is what happens anytime you see the word control or controlled appear in the Income Tax Act, with no modifications in addition to that word. And so, what de jure control is has been defined by case law. There's an old Exchequer Court case from like 1966 called Buckerfields Inc. And there's a more recent Supreme Court decision from 1998 or so called Duha Printers. And what the courts have held in those cases is that de jure control requires an examination of the corporation's constating documents, the governing corporate law statute, any unanimous shareholder agreement of the corporation, and the share registers of the corporation in order to determine who has the power under those constating documents and statutes to elect the directors of the corporation. So in most instances, the majority shareholder of the corporation, whoever owns the most vote, whoever owns more than 50% of the voting shares, will be the person who has de jure control, because they could elect a slate of directors all by themselves, with no one else's involvement. Therefore, they control the corporation. This can be modified by unanimous shareholder agreement if the unanimous, as was the case in Duha Printers, where the unanimous shareholder agreement actually gave somebody other than the majority shareholder the right to appoint the board of directors and therefore to manage the affairs of the corporation. But by and large, if you own more than 50% of the votes, you control the corporation de jure. For these purposes, we do not care about voting trusts or similar documents because they're not constating documents. Those are agreements between shareholders. What we care about are items that either, like the share registers, just inform, or things that bind all of the shareholders, like the articles of incorporation of the corporation, the unanimous shareholder agreement, or the Business Corporations Act. The other kind of control is what we call de facto control. And this is what you see when the words controlled directly or indirectly in any manner or whatever pop up. And what that's referring to is any kind of influence over the corporation that, if exercised, would be tantamount to being able to change the composition of the board of directors and therefore to control the corporation on that basis. Historically, the inquiry here was whether the person could do something that was equivalent to changing the board of directors or exercising a very heavily or exercising a very heavy influence over the persons who could appoint the board of directors. It didn't matter what the source of that influence was, and it didn't matter whether the influence was ever exercised or not. The mere existence of that level of influence was enough to cause a de facto control relationship to exist. What recently happened was where we see this subsection 256.5.11. There was a federal court of appeal decision called McGillivray Restaurant, and what the court held in that case was that when you're looking at de facto control, you're not looking for nebulous influence. You actually have to, what the federal court of appeal said in that case is you have to look at legal relationships, and you have to find legal relationships that would cause this influence that would be tantamount to de jure control if exercised. And so Parliament decided to override that decision. They enacted subsection 256.5.11, which basically said that when you're looking for de facto control under subsection 256.5.1, that you look at all the facts and circumstances and not just legal relationships. So the law basically got put back to where it was before McGillivray Restaurant. Interestingly enough, McGillivray Restaurant is a weird case because the taxpayer still lost even after the Federal Court of Appeal decided to go and gently restate the law in order to require that there be legal relationships. The taxpayer lost in that case. The court found that Mr. McGillivray had de facto control over a corporation incorporated by his wife because the court found the existence of an oral contract between husband and wife under which wife would appoint directors and make director level decisions as dictated by husband, which, if you're going to pull oral contracts out of thin air, I don't really know that that's much better than just examining all the facts and circumstances to determine if de facto control exists. But, you do you, Federal Court of Appeal. So in any event, you don't need to go find make-believe oral contracts in order to get to the result you want anymore. You can just look at all the facts and circumstances to determine if there is de facto control. Interestingly, just because Thomas had posted some questions about SR&ED, post McGillivray but pre subsection 256.5.11, there was also another case called Aeronautic Engineering, which was actually an SR&ED case where it mattered if a non-resident corporation had de facto control over a Canadian corporation because they were trying to claim refundable SR&ED tax credits that were only available to a CCPC. And in that case, again, the court basically found some evidence in the existing documentation and some mumbo jumbo oral contracts. And on that basis, the taxpayer lost as well. So it really was unclear what subsection 256.5.11 actually does, given that the courts were just inventing oral contracts out of whole cloth in order to get to the same result as if subsection 256.5.11 existed. But here we are for greater certainty. So subsection 256.5.1, which is our de facto control definition, it's very, very broad, right? At least on its face, especially now that 256.5.11 is there to say that it is supposed to be, incredibly broad. But if you're looking at the provision, you'll see that there's some carve-outs in there, right? And the ones that are listed there that are, especially important are rights that exist under a franchise agreement or a lease. Any kind of control over the corporation or influence over the corporation that another person exercises because they are the franchisor or the lessor under a lease or a franchise agreement, as the case may be, is disregarded in determining if that person exercises de facto control. And this is because Parliament is trying to not cause de facto control to arise as a result of arm's length contractual relationships, where the purpose is to control the conduct of the business to preserve goodwill and not to control the actual affairs of the corporation itself, which, sometimes I can seem like a very fine distinction. I know certainly if you look at some of these, for example, fast food franchise agreements, like they are very onerous in terms of what the corporation can or cannot do. And you kind of wonder if it really is trying to control the affairs of just the business, or if you are trying to control the affairs of the corporation as well. But that is a distinction that Parliament has drawn. So, do be aware of that and make sure that you're not over applying subsection 256.5.1 as a result. Next, if we flip to slide 10 of Deck 2, we're going to talk about briefly about paragraph 251(5)(b). And what this provision does is, for very limited purposes, it deems rights to acquire a share, rights to cause a redemption of a share, or rights to exercise votes attached to a share are deemed to have been exercised. And this is intended to be an anti-avoidance rule, but it applies fairly narrowly and applies only for the purpose of determining if two or more corporations or two or more persons are related. We're going to talk next week or the week after about what it means to be related, so don't worry too much about that one right now. The other place where it applies is for the purpose of determining if a corporation is a CCPC or not, which, you know, that does matter in a more proximate sense, since we know that you know, CCPCs can't be controlled by certain people. So this is intended as an anti-avoidance rule, right? The idea here is that we wouldn't want somebody to effectively control a corporation because they have a right to acquire all of the shares or to just swamp the outstanding shares for no consideration, but still have that corporation be a CCPC and qualify for the small business deduction or for refundable SR&ED credits. We don't want that, because having that option to acquire all the shares for no consideration or swamp the shares for nominal consideration is tantamount to owning all the shares, right? If that option is exercisable anytime. And so the corporation should be treated as though it were, you know, it should be treated as though it were owned by the person who holds that option. So that can be a, you know, that can be a very important rule in dealing with CCPC status. Again, it can apply in determining if two or more persons are related. What you're going to see is that paragraph 251(5)(b) actually gets carved out by a lot of provisions that turn on relatedness. We're not going to talk about most of them in this course. For example, you know, the bump rules or the butterfly rules, which are very important tax planning rules, generally carve out the application of paragraph 251(5)(b) in determining if people are related, which is, you know, important to keep in mind. But by and large, anytime you need to know if people are related, you do need to take paragraph 251(5)(b) into account, at least initially. The other thing it asks on the side is how paragraph 251(5)(b) applies and how it relates to subsection 256(5.1), which is the concept of de facto control. And the answer is that they're complementary. They actually don't, one doesn't impact the other, but they kind of get you to the same point, right? Like we're often concerned with subsection 256(5.1) and de facto control in determining if a corporation is a CCPC or not. You know, we often very much care about that, and so, you know, because of rights that are not in the constituting documents of the corporation that would be effectively allowing people to control the corporation, paragraph 251(5)(b) kind of gets you to the same point, right? Except using options that, if you were going to use options to create a right that was tantamount to controlling the corporation, it's going to be the same outcome, where the right is going to be deemed to be exercised for the purpose of determining if you've got a CCPC, and therefore you just will not have a CCPC if the person who holds that option is a public corporation or a non-resident. So, you know, highly complementary. The one thing to, I guess, that should be pointed out is that they can both apply in circumstances where the other wouldn't. So there are places in the Act where de facto control can be relevant, but that are not the CCPC definition and are not somewhere where relatedness matters. And so in those circumstances, subsection 256(5.1) can apply, but paragraph 251(5)(b) will not. And similarly, there are places that will either use the CCPC definition or that will turn on relatedness or control, but will not use the de facto control magic words, you know, directly or indirectly, in any manner, whatever. And so paragraph 251(5)(b) may be relevant, but subsection 256(5.1) is not relevant. So flipping on to slide 11, we have this concept of indirect control. So the courts have formed the view that a corporation cannot have two masters. And what this means is that a person who has de jure control of a corporation will also have de jure control of all of the subsidiaries of that corporation, meaning any corporation that the corporation controls. So for example, if Mr. A owns all of the shares of Holdco, and Holdco owns all of the shares of Midco, and Midco owns all the shares of Opco, then Mr. A has de jure control of both Midco and Opco by virtue of having de jure control of Holdco. And it doesn't necessarily need to be that these are 100% owned all the way down. It can be 51% owned all the way down, and the result is the same. And so this is a rule from a case called Vineland Quarries, which is, again, a very, fairly old case, probably from, I think, the 1960s, just offhand. In Parthenon Investments, which is a more recent case, the courts also held that this rule applied from a bottom-up standpoint as well. And so in that case, the courts were concerned about were asked to think about a situation where a Canadian corporation was directly controlled by a U.S. corporation, and the U.S. corporation was in turn controlled by a top-tier Canadian corporation. And the Canadian corporation was controlled by Canadian residents ultimately. And the court was asked to consider whether the corporation was a CCPC or not. And the CRA's position was that because there was this direct control by the U.S. corporation, the corporation could not be a CCPC because it was controlled by a non-resident person. But the Federal Court of Appeal ultimately held that the corporation was a CCPC because applying the rule from Vineland Quarries, the top-tier controller of the corporation was a Canadian resident corporation, and therefore, on this idea, the corporation cannot have two masters. The corporation must have been a CCPC because it was ultimately controlled by a Canadian resident corporation. That was not a public corporation. So what then happened, as often is the case, is that Parliament decided that they didn't like this result, and they overruled it by enacting subsection 256.6.1. And the wording of this provision is convoluted. But basically what it does is it permits simultaneous control. And so what that means is that a corporation can be controlled at the same time, both by its direct majority shareholder and its indirect majority shareholder, which is basically the person who can control the majority shareholder. So what this would have meant in Parthenon Investments is that because there was direct control by the U.S. corporation, the corporation would have been simultaneously controlled by the U.S. corporation and by the ultimate Canadian parent. And so again, obviously being controlled by two people at once is kind of an impossibility, but in this legal fiction world that we're operating in at the moment, the effect of that was that the corporation was controlled by a corporation that was not resident in Canada, which was the U.S. corporation, and therefore it would not have been a CCPC had subsection 256.6.1 been in existence at the time that Parthenon Investments was decided. So this is actually an interesting rule, which in practice you are going to see that this rule gets used to cause corporations to not be CCPCs when you have investment income that you want to defer tax on. And you'll do this by just jamming a non-resident corporation into your chain of ownership in order to cause the corporation to be controlled simultaneously by a non-resident corporation and a resident corporation, which is, it's cute. It works very well, and you're less worried about the GAR applying in those circumstances because Parliament specifically enacted a provision to do the exact thing that you're attempting to do. So, some fun to be had with the simultaneous control rule. And then finally, if we flip, actually this may not be finally, there's, and this is finally, this is the last slide before we finish topic number 2 and move to topic number 3. The last clarifying rule that we do need to point out, because it matters in classifying your types of corporations, is corporate residence. So the main deeming rule that we care about here is subsection 254, which deems a corporation incorporated in Canada after April 26, 1965 to be a resident in Canada. So without regard for whether the corporation is actually managed, if it's incorporated in Canada after that date, it's resident in Canada. What you're going to see again in practice is that there are very few corporations in Canada, that were incorporated in Canada that are more than 56 years old at this point. And there are, especially because even if those corporations do exist, they tend to be reincorporated in some way as a result of a continuance under a different BCA, as a result of an amalgamation or something similar. So, a good rule of thumb in practice is that if the corporation is incorporated in Canada at any point, it is a resident of Canada. It's deemed to be a resident of Canada under subsection 254. Sometimes you will infrequently come across a corporation incorporated before 1965. The minute books for those corporations are hilarious, just in terms of stuff that you would never see now. Like, for example, when you have a female shareholder describing her occupation as married woman, stuff like that, that was just absolutely not kosher in 2021. And you just wonder what people were doing in the 1950s, et cetera, that they thought that was a good idea. Something like that. So you can be a little bit amused by some of these minute books. But you're going to encounter those like once in a decade sort of thing, not on a regular basis. However, this result that a corporation is deemed to be a resident in Canada, regardless of as long as it's incorporated in Canada, deemed to be resident, regardless of where it's managed, there is a little bit of tension here because we have a different deeming rule in subsection 255. And what that rule does is if a corporation is deemed to be resident in a different jurisdiction under a tax treaty, then it's deemed to be not resident in Canada and to be resident in that other jurisdiction for purposes of the Act. I think the UFA canceled the international tax course. This is where I'd usually say that you would learn more about 250 sub 5 and tax treaties and international tax. But I don't know that we have that course anymore. So you may not learn about it there. But this one, again, very infrequently comes up in practice because for the most part, if you're going to have a cross-border transaction, especially in Edmonton, almost all of them are with the United States. And the United States uses the place of incorporation rule to determine corporate residence. So there actually is no conflict of law between Canadian law and U.S. law when you have deemed incorporation residence in both places. It is still going this term. Nice. Okay, so you will learn about it on Thursday nights. Wow, I'm looking to be worse than Friday afternoon. Apparently Thursday night. So you will learn about. Okay, it's not running next year. Tragic. You will. Those of you who are fortunate enough to be taking it this year and not getting boned by the fact that it's not available next year, you will learn about that rule. It is actually. I actually do have a live file where this is a problem, where we have a corporation resident in Canada that somebody wants to use as a blocker to cause their partnership to remain a Canadian partnership after they move to the UK. But the UK uses a place of management test, and our treaty with the UK has a place of management tiebreaker and then competent authority tiebreaker. And so that actually creates problems where the person who controls the corporation is moving to the UK. And we actually do have to think about how the UK treaty will work, and we'll probably end up having to get a ruling from the UK that they're not going to treat the corporation as resident in the UK, so that we don't have to worry about the treaty tiebreaker booting us out of Canada and causing a very large partnership to not be a Canadian partnership anymore. So this does come up. It's not a total hypothetical thing. So the last point on the slide is the common law test, and this is important in two instances. One is if you have a corporation that is in fact more than 56 years old, and so it's not deemed to be resident in Canada, and you have to figure out whether it is resident in Canada or not. The other is if you have a corporation that is not incorporated under Canadian law, and you need to figure out whether that corporation is resident in Canada or not. And again, ignoring tax treaties here. And so that's where the common law test comes in, because just like individuals, corporations can be, corporations are resident in Canada if they're just resident in Canada, or if they're ordinarily resident in Canada, which is, again, not a defined term. And so here, there is a common law test for residents. We are unique relative to, for example, the United States, which has all bright line tests for corporate residents. We have this common law based facts and circumstances test, and it's called the Central Management and Control Test. And basically, to use the language of now dead judges, it is a test that looks into where the corporation keeps house and does business. And so basically what this means is it's an inquiry into the place where the director level functions of the corporation are actually exercised. So it may not necessarily be the place where the directors meet. If, for example, the directors have been usurped, or if the directors really make their decisions outside of the director meetings. But the point is that you are looking for strategic management rather than operational management. And it doesn't so much matter where the directors are at any point in time, like where they live. It just matters where they actually make decisions. Again, you could have a situation where the directors make decisions is irrelevant if the directors have their powers usurped, or if their decisions are dictated to them by some outsider. However, by and large, as long as you have your directors meetings in the place where you want the corporation to be resident, and you actually transact business properly at that meeting, and the directors are really empowered to make the decisions that you purport that they're going to make, then the corporation will be resident in Canada. So, for example, if you have a very old corporation, and the directors actually exercise their powers and they meet in Canada, the corporation will be resident in Canada. Similarly, if you have a foreign affiliate of a Canadian corporation, and the foreign affiliate has its, is incorporated under, let's say, Swiss law, and the board of directors actually, meet in Switzerland. So any Canadian directors, every time there's a meeting, get on a plane to Switzerland. Again, in pre and post COVID world, not right now, get on a plane and go to Switzerland. There's actually Swiss resident directors, and the directors have all the information they need to make decisions, and they actually diligently exercise their decision-making function. And then the corporation will be resident in Switzerland, and your foreign affiliate will be resident in Switzerland, and you'll generate exempt surplus, and everything will be good. So that is topic number 2. So with all of that, we kind of have what we need to do to actually get really deep into the mechanics on corporate tax. Before we jump to topic 3, does anybody have any questions?
Just to clarify the difference between de jure control and de facto control, would it be fair to say that de jure control is straightforward? Whoever seems to be in charge actually is in charge, and de facto is the opposite?
Yeah, I think that's fair. There's every once in a while you will have a case where the CRA wants to pick a fight about exactly what de jure control means. But yeah, by and large, it's a black and white test, right? You either have de jure control or you don't, and you should be able to, as long as everybody agrees on what documents need to be looked at and how those documents are interpreted, then everyone should agree on who has de jure control of the corporation. De facto control is, as the name implies, a question of fact. And so, especially since now that we've legislated that it's a pure facts and circumstances test, you do have to identify and take guesses as to what kind of influences might exist that could be tantamount to, would be tantamount to controlling the board of directors or replacing the board of directors, and who actually has those powers, and then whether or not they're carved out by a franchise agreement or lease or similar document under 256.5.1. So yeah, it is certainly dicier. And you do worry about that rule, absolutely, especially in circumstances where you're trying to avoid de facto control. So, for example, where you're trying to, if you have a non-resident corporation, you're trying to have their corporation, their sub in Canada be a CCPC, and you're structuring. This is the classic SR&ED refundable SR&ED tax credit structure, where they would have a Canadian resident trust would control the corporation, and the public corporation would be a beneficiary, and one director of the public corporation would be a trustee, and there'd be two other trustees who are resident in Canada. And the position was that the public corporation in the U.S. didn't control the Canadian resident corporation, which was doing the R&D and generating refundable SR&ED credits. Those actually don't really work. People have run those to trial and lost, but that was the idea, right? You have to get into the question of fact, like does the public corporation's nominee, who's a trustee of the trust that controls the R&D corporation in Canada, like does that person actually dictate all of the decisions that are to be made by the directors? The answer is invariably yes. He or she does, and so then you have de facto control. So it is much more uncertain, and there is always a risk of an adverse result.
Could you say that within one company, could one person have de jure control and another person have de facto control? Or is the fact that someone has de facto, you could have both?
Oh yeah, absolutely. Yeah. You absolutely can have a difference between de facto control and de jure control. So
the person with de jure control actually may not have control.
Yes, exactly. So which can create interesting, I think there's a case we're going to talk about in the other next, I don't know if it's next week. When we talk about association, I think we're going to talk about a case called Kruger-Wagamayak. And in that situation, like there were differences between de facto control and de jure control. Like one person had one, somebody had the other. Certainly, what you're going to see is in practice, where you're going to see this is the classic small business deduction multiplication structure, where you're going to have a joint venture between two corporations, one controlled by husband, one controlled by wife. And usually in these, just to stereotype a little bit, but in these situations, what you usually will have is that wife will have de jure control of one of the corporations, because she'll own all the voting shares. But as a matter of fact, in most of these situations, husband just calls the shots, and so he will actually have de facto control. And so that one comes up in practice a lot, where there's that split between de jure and de facto control. Okay, so I saw there was a question in the chat. Why the ABCA has sections like 105 sub 3 requiring a quarter of the directors to be resident Canadians, when the resident test on management and control management is easier to meet. So the answer here, funny answer number one, is that the Red Tape Reduction Implementation Act 2020, which was passed by the Alberta legislature over the summer, actually repeals subsection 105.3. That repeal was effective on proclamation, not royal assent. So that act has received royal assent, but there hasn't been proclamation. So right now, subsection 105.3 is like the Schrodinger's cat requirement, where it's both living and dead, where at some point proclamation will happen, it will be repealed potentially retroactively, but it hasn't happened yet. So we don't, but anyway, pretending that subsection 105.3 continues to exist, I don't think it's related to tax, to be honest. I think the idea is that they want corporate, because in many provisions of the BCA, for example, the corporate law solvency test, etc., the remedy if you breach is that you get to sue the directors and they become personally liable. So I suspect that the reason that 1/4 requirement is there is actually not tax related. I think it's there so that there's a Canadian resident person who you can sue. I suspect, I do not know, that is the answer why. I don't think they were thinking about tax when they did that. Yeah, so, no problem. So interesting enough, as I mentioned, we have repealed that effective as of an uncertain date. We will not be the first jurisdiction. BC, for example, does not require Canadian resident directors. So one thing, again, that you will see in practice as tax lawyers is that often where you have inbound investment into Canada from another jurisdiction, people will often not want to deal with the formality of having Canadian resident directors for their Canadian resident corporation, who they would have to pay to be directors. And so they'll often, even if they're acquiring a business in, for example, Alberta or Saskatchewan, they'll incorporate their acquisition corporation in BC in order to avoid the director requirement. I believe Nova Scotia may have the same thing, but I'm not 100% confident on that. So, you know, just an interesting thing that where this best practice may change and people may start using Alberta instead of British Columbia for that purpose once we've actually implemented the repeal of 105(3). Anybody else? Okay, seeing none, let's flip to deck 3 and slide 2. So we're picking up now at handout number 6. And we're starting here in the same place that handout number 6 does. And we're reiterating that corporations are taxed in substantially the same way that individuals are taxed. And the same computation rules apply. So whether or not you're subject to tax at all is determined under section 2. You aggregate your income and losses from different sources under section 3. The rules for business and property income in sections 9, 13, 18, 20 apply. The rules for capital gains and capital losses in sections 38, 39, and 40 apply. So at a very basic level, you're not going to have to relearn anything in order to figure out what the taxable income of a corporation would be. There are a couple differences in the tax base, however. The first is that corporations can't earn employment income. So just like a partnership, they're not individuals. So sections 5, 6, 7, 8 will never apply to a corporation. You can basically just disregard those sections for the purposes of this course. The other difference that we're going to see, I don't think it's going to be this week, but we will see it, is that corporations get to deduct dividends received from other corporations. In, again, not all instances, but in most instances in a domestic context, that deduction is available. So that's a fairly significant difference in the tax base between individuals and corporations. But those two things aside, pretty similar. Where we are going to see a difference, significant difference that we're going to spend a lot of time on, is in rates. That's where the really big difference is. For the reasons we talked about at the beginning of the class, corporate rates are going to be much lower than individual rates. And furthermore, there are tax expenditures available to corporations that further reduce rates or that reduce effective tax rates that are not available to individuals, and vice versa. For example, we'll talk about some of the tax expenditures that apply to corporations, but on the vice versa point of tax expenditures that apply to individuals, corporations don't get medical expenses, basic personal amount, child care deductions, elder care deductions. They don't get anything for families, really, because corporations don't have families. They don't get, I think they repealed the textbook credit, but they didn't get that before. They don't get transit pass credits. They don't get volunteer firefighter tax credits. Truly the dumbest tax credit we had. They also don't get, like we talked about last week, they don't get credits for charitable donations. They get deductions instead. In many ways, these rules are, the fact that you don't get all of these weird tax expenditures that don't often make coherent sense, or that you get them in the form of a deduction rather than a credit. You can often chalk that up to corporations not voting, right, as being a pretty important difference, aside from any actual policy motivated difference. Moving on to slide 3. We now start the heavy lifting of learning how we actually get to an effective corporate tax rate. So what you're seeing on the slide is basically the process that you have to go through, although without the relevant sections listed. So the first step that you're going to take is to figure out your default federal rate. So the way that you do this is you go to subsection 123.1 and you see 38%. And in theory, that's the federal corporate tax rate, is 38%. We all know that is not actually the federal corporate tax rate, but that's what it is and where you find it. So then, we're going to go through each of the next few steps in more detail, but at a very high level, what you're going to do, the next step is you're going to subtract the provincial abatement, which is effectively if any income is earned in a province, it's a 10% reduction. The way you tell if income is earned in province is determined under Regulation 400. And basically, if a item of income earned by a corporation is attributable to a permanent establishment in a province under Regulation 400 at SEC, it's deemed to be income earned in the province, and that qualifies for the provincial abatement, which is a 10% deduction from the rate. So this effectively drops the rate from 38% to 28% at the federal level. Then, if the corporation is a CCPC earning business income that's not small business deduction eligible, or is a corporation that is not a CCPC earning any type of business income, then you deduct what we call the general rate reduction percentage. And this is basically a 15% further reduction. So that takes our effective rate down federally from it should be 15, it should be 13%. So it's a 13% reduction. It gets you to 15%. I misspoke there. So at the end of the day, in those circumstances, where it's a CCPC earning business income, and very specifically business income, as we'll see in a moment, that is not eligible for the small business deduction, or is a non-CCPC earning any type of business income, take your general rate reduction percentage, which is a 13% drop from 28% to 15%. So that's the federal corporate tax rate in a nutshell. So when you hear the federal NDP talking about how corporations in Canada are really only taxed at 15%, they're kind of right, but they're also extremely wrong in the sense that they aren't accounting for provincial taxes. And in a federation like Canada, provincial taxes matter to a very great deal, as we all see. So then, when you have that rate, assuming those are your items of income, it is just business income or it's a non-CCPC, you then do have to add the provincial tax rate. So in Alberta, the provincial corporate tax rate for 2021 is 8%. And that's our general rate. So anything that's not small business deduction eligible is taxed at 8%. So that brings your integrated rate to 23%. So that's the lowest rate in Canada. Generally speaking, Canadian provinces' corporate tax rates are about 25% to 31-ish% in New Brunswick. For the most part, the corporate tax rate in most provinces, once you have added back the provincial corporate tax rate to the federal 15% rate, you're usually at about 27% in most provinces. That's where Alberta was, prior to the UCP being elected in 2019. BC's at 27%, Ontario's at 26.5%, Quebec's at about 27% as well. So the major provinces are all kind of in that range. Saskatchewan, if anybody cares, is also 27%, but like nobody cares about Saskatchewan, so we probably won't talk about it again. So that's CCPC business income in excess of small business deduction cap or non-CCPC income of any type. So then the question is, well, what happens if you have, let's say, small business deduction eligible income because your corporation is a CCPC? So in that case, the general rate reduction percentage would not be applicable. And instead, you would take the small business deduction. And the small business deduction is, instead of being a 13% reduction to the federal rate, is a 19% reduction to the federal rate that takes it down to 9% from 28%. And then again, you would be adding the Alberta small business deduction rate, which is 2%. And that's where you get to this rate of 11% for small business income in Alberta. And so we're going to spend a lot of time talking about the strictures of what income is or is not eligible for the small business deduction, what can grind your small business deduction eligibility, et cetera. But that's basically it, that only CCPCs qualify for that small business rate only on certain income. But if they do qualify, it's 11% in Alberta instead of 23%. But suppose you have a CCPC and it's not earning business income at all, and it's in fact earning investment income. Well, in that case then, what's going to happen is that you're not going to have either the general rate reduction or the small business deduction rate apply. So your rate is stuck at 28%. But what happens is, instead of a further rate reduction, you actually have a rate increase where there's now an additional tax of 10 2/3%, which takes your effective federal rate from 28% to 38 2/3%. And then you add on the provincial tax, which, since this is not small business deduction eligible income, is going to be at the 8% rate. And that gets you to 46 2/3% as the effective combined federal rate in Alberta for basically for investment income of a CCPC. So there's also that. What you will, and there is also a separate rate addition as well for income that's earned by a CCPC from a personal services business. And we'll talk a little bit about what a personal services business is later on. But if you do have a personal services business, you also don't get the general rate reduction. And you also have an add back onto tax. And so you land at a 43% effective tax rate in Alberta in 2021 for personal services businesses. But basically, we don't super care about that right now. So your important ones are that you have an 11% rate on small business income in Alberta in 2021. You have a 23% on general corporate rate income, a 46 2/3% rate on CCPC investment income, and a 43% rate on personal services business income. So none of that is including shareholder tax, but that's the very high level, and we're going to see how you get to those rates in painful detail. So with that, I think it's also a good time for a break. So if does anybody have any questions before we stop recording and take a break?
Sorry, can you repeat the provincial abatement test?
Sorry, Leah, you're very faint. Would you be able to just repeat the question? Either, I don't think it's a you not speaking up problem. I think that's a microphone problem. But if yeah, sorry, can you repeat the provincial abatement test? Yeah, so the provincial abatement, we're going to talk about this more after the break. So there's more detail to come, but basically the provincial abatement applies if under the regulations income is treated as having been earned in a province. That's the test. And so if it's earned in a province, you get that 10% reduction of the federal rate from the top line 38% down to 28%. No problem. Anybody else? Okay, seeing none, I'm going to stop recording.